April 13th. It is 4:03 p.m. and this is a meeting of the Policy Committee of West Bend School Board. Joel Leonard, Chris Whiter, Superintendent Jen Wimmer, and Lenny Hansen, Director of HR. And we're going to be reviewing the 500 series policies tonight. So in board docs, under our meeting and agenda, we will I'll make a motion here in a second to approve the agenda, but for the public who may be watching live at home or watching a recording, everything that we're reviewing tonight is under the public content. It's a PDF that you can open with, it looks like 74 pages of policy. The pages that we're flipping through up here are the 74 pages that we've just printed out so that we can flip through them as we go through this, but it's all available to the public on the board docs there. So with that, I will make a motion to accept our agenda for tonight, which is a review of policies 500.
Second.
Great, and I'll just make a note that Paul Fisher is excused absent tonight, so we do still have a quorum of this committee with me and you. So
Okay.
With that, all in favor say aye.
Aye.
Aye. So we've got our agenda. Let's move on.
All right, again, the meeting was noticed and people can find it live. You can find policy in a couple places, not only the work that we're doing tonight, but also policy is linked live. We're talking about the 500 series, which is personnel, but all of our policies are found online in the section labeled policy, so you can see the different series. In this category tonight, you can certainly click along at home for the different numbers as we call them out, or we've conveniently scanned that packet for you. The first thing we do when we look at policy, again, we work with the Wisconsin Association of School Boards. They provide technical legal assistance when reviewing and writing policy. We go through all the series, not just the 500 series that we have in place, but all policies available to us, those templates, those recommendations, to make sure we're in compliance with the ones that are mandated, that we have policy in place for those that are recommended by them as an organization, and some things that are just sound practice. So you'll see those tonight. So we've got a couple new ones, but we've been doing some consistent cleanup. Those of you who follow the policy committee will know sometimes we need to renumber items. So as we need to look at replacing language, renumbering, that's why the PDF is there. It's a little bit easier to follow. We'll go through and make notes as we go. So anytime we have any questions, both Lenny and I can speak to the research that we've done, the recommended language, current language, etc. Okay. All right. Yeah. Yep. And they're also found right, you can scan in there too. So the first one is, again, 500 deals with personnel. It's all your staff policies. The first one is the equal opportunity employment policy. Again, we printed them out because the one right behind it is the old policy. It's shorter and was from 2015. The 511 in parentheses, it says new WASB template language. That just is a reflection of the latest recommended language from WASB. So we'd be looking at a removal of our former language and updating to the current. I'll take time for you to take a look at that and ask questions.
My initial reaction on this one, and we certainly can examine it even closer, but when we're talking about equal opportunity employment, my assumption is there's a lot of federal regulation on this, and it seems that this policy the revised draft brings in more of those references and that character and flavor, and so my first reaction was favorable to this.
And the other point, you bring up a great piece, and it's probably fresh in our minds. We updated policy 113. There's certainly an intersection here that lays out, there's a reference in this one, but it lays out exactly who the reporting officers are, how to make different complaints, where the intersection of these policies lie, and kind of cross-references very heavily in that one too. So.
When you talk about those federal regulations, so one of the changes since this was last updated is the federal government significantly updated Title IX process, and that needs to be reflected in here. So that's part of the reason for more lengthy language in here.
Looks good to me. I think this is good, and I think worthy of board consideration.
Okay. That was one thing that as we go through, this is the first time Mr. Hansen's kind of doing policy in this manner. I said at the table, we'll talk about things that you might want to come back. We always put aside another meeting if we're having to reframe, talk about different philosophy, but some you might say, go ahead and this one's ready to take forward. So that's how we'll know this one could go forward. And again, that would cause the removal of the current one. It's just cleaner to do that way. You'll notice behind that, there was a 511 AR. We said we'll update this after a review of new policy. Again, that's just really making it clear for staff to go to that, give the updated addresses, contacts, et cetera. So we'll make sure that that's updated with that and makes it easier for staff. Another one is 512, that's harassment of employees. Right behind that in your paperwork, you had 512, we have new WASB template language. And right behind it was 512.1. That's what we had as harassment of employees in the past. This not only reflects the appropriate number, but it's updating the language again. This was from 2015, so it would be a remove and replace with the new language.
I think my comments would be similar on this one. It looks like this one has a crisper tie to the applicable federal law. And so, again, my initial reaction on this was favorable.
And again, you're correct, and a lot of these are guided by statutes, federal laws, et cetera. We're just restating, maybe making those definitions clear and accessible in policy and giving them those other resources as well. So that would be the same on those two.
There's not a HR on an AR, excuse me, on 512, huh?
No, there is not,
On filing a complaint or?
there's a separate complaint policy that would also be in that umbrella. So again, we can make sure that we've got that clear, or we can, in that other AR, oh, if this, then this, and just make it clear to an employee too.
And there's no AR in the current one that we would need to replace, so.
Sounds good.
The next was 519. It was a code of ethics. This was our own language. We recommend renumbering it to 522.4. That's more in alignment with the manner that it was there. We really reviewed, Lenny did a nice job of again, this is some homegrown language, just making sure that we're still in alignment with that. And these were things, a lot of times he's, as the Office of HR, executing on these policies, that these were in alignment with practice now as well as future practice.
And then this one, like several of these policies, also appears in the employee handbook. So we often duplicate that language in both places. So depending on what the board chooses to do on these, we would also replicate in the handbook. And this one is one of the featured items that is in the handbook, is the code of ethics.
Or again, it's this is not one of those that is required. Clearly, we wrote this language and we're restating. You can choose to have it just present in the handbook. You can have it dually present as we do now. It exists. It's been working for us. He utilizes it in HR. We're fine. We would just recommend renumbering.
And reading through these bullet points, I don't think any of these are detrimental. I mean, these are all good expectations.
Mhm.
And so I have no problem keeping it here. I think it emphasizes its importance if it's in both places, both the employee handbook and the policy.
Yeah, and I think that as committee members, we started this year with your overarching philosophy of making sure the policy was transparent for our public, written in plain language. Again, as to your point, not just making it clear for employees, but our expectations to our community of ourselves is important too. Okay. The next one is staff and student relations. You can see we've got some strike-throughs on some language, some things we recommended a little bit of reordering, so you can see that highlighted. This should be renumbered as 528, staff-student relations, and then we've got these suggested revisions that are present in markup language. Gives a little bit of kind of a preamble, if you will, and puts some things in different order.
On the strike-through language, so we're not saying we don't care about those things. It's really just redundant. The bullet points there end up being redundant with what is in the paragraph after. So that's the reason for the strike-through. Certainly not that we
Would
are
that also
changing the expectations. communications.
The very last paragraph with the 3 bullet points. Do you want to keep those 3 bullet
Yep,
points?
they're on the next
So they-
page.
they
We
Those 3
reordered
you
it.
want to keep, but not the bullet
When you'll
points.
see some of those are the same, we kind of reorganize how that language works. So that lower paragraph kind of takes some of that strike.
Oh,
So we're honoring
I
that we
see, yeah.
struck it through there, but you'll actually see that
I see.
language right there.
It gives it a little bit better preamble with that paragraph that starts with furthermore on the back.
Yep, I got you.
Looks good.
The next was staff use of social media and online systems. Again, this was something that the district has kept pace with. The last review was July 13, 2020. It's reflective of the most recent language and current practice. We recommend no change to this.
It's the right numbering,
Correct?
you said?
Yeah, again, relatively recent, July of 20.
And Mr. Harder, our technology director at that time, was involved in ensuring the update made sense with, you know, the latest technology needs were.
Yeah, I vaguely remember this from a couple of years ago, so if it still looks good to you, it's fine with me.
Yeah.
Good.
The next one is 521.1. It's a new template language. Again, it's replacing 520. You'll see 520, the original, right behind it. Our 520, it goes through a lot of the same things. It talks about chain of communication, expectation for not just staff, but also for you as board members around, you know, how to route your communications, what's best practice, expectations that you have. We look through all the steps that we had in our previous language, and they're really mimicked, maybe not in bullet fashion, but just the different interactions and communications. We feel that it's largely representative. On the back of our original policy, there's a chart. It's, you know, then you're flexing with titles or people. This is just a little bit more comprehensive overview without having something to be tweaked continuously if the name changes or title changes. But its intent is still there.
Give me just a minute.
Yeah, take some time. And again, really going through a key into staff interactions with board members. It's been the board's expectation around, again, we believe strongly in chain of command, communication, really helping get people connected to. I think it happens to any of us in any of our roles. We might be somewhere and someone might say, hey, I've got this, how do we help as a liaison almost in getting people connected to the right person to bring resolution or recognition to something?
So can you describe the interplay of this with other policies? So for instance, it says to replace, this one is to replace 520, which is right behind it, correct?
It's right behind it, and when you go through this one, if you want to take some time to just reorient yourself on this, it's digging into the same philosophy around go to most direct point of contact, here's your people, but it's laying out sometimes specific titles, like we don't even have some of these titles anymore. So, you know, then you're dealing with something on that. We do have then an orientation piece on communications that we run, I believe is a consistent presence on the website. I can make sure that's still there. It gives you like, oh, if it's something about buildings and grounds, here's a point of contact. And then we run that to our families in a first newsletter, helping them know who do I connect with about what.
And I don't want to jump around too much, but as you think about what the number is replacing, what we found when we talk about the current 520, that is, it's around employees talking about their concerns and those sorts of things. That's already covered in our other, like policy 872. So by keeping the existing 520, you actually have side-by-side different practices for addressing concerns, which is obviously not good practice because which policy are you supposed to follow? So that's the other reason that this kind of replaces. The new one creates more of a philosophy and framework around how that communication should work, whereas the actual process for, okay, immediate supervisor, next in line for a concern, that's laid out in 872 already. So rather than, otherwise we end up with two different policies, an employee can bring a concern and it's which one should we follow, and there's different timelines, different chains of command. So that's one of the reasons we get to 520, that we would pull that one out.
I'm glad you brought that up because I was having flashbacks to when I read the instructions for public participation. There's a section in there that says, we advise that if you have an employee complaint, this is what you should follow. If it's citizen complaint, that's what you should follow. And I was trying to remember if they refer to 520 or meaning if we're going to change where this should be pointed, we may have to look at cross-reference that policy as well. I'm trying to find now. That's Board Policy 187 is public participation, I think.
And 872 is the complaint policy.
That's one that's referred to, I think. Let's see.
That is the one that I believe is referred to in that language that you read, because really anybody can use 872. Not just, anybody has access to that.
Yeah, these were 872 with citizen complaints, and it was adopted on the same date as this one, which is, at the time, it was entitled Employee Concerns or Complaints. It was completely West Bend School Board language at the time. And I don't know that it's ever been used by an employee since it's been adopted, ever.
It has not been used in my almost 3 years in this role.
Citizen complaints have,
People use 872, yeah. that's-
rarely, but they have. As an employee, I think this new WASB language is just so much more, it's just common sense. It's, if you have a problem or a complaint or communication expectations, the first person you should go to is your immediate supervisor. And then at the bottom, of course, it talks about board members, where if an employee goes to a board member, if a board member goes to an employee, what the expectations are there. It's common sense to me. It's simple.
And Chris, it is in there in that policy where it says policy 872 and 520. You can do two things. I can bring that one forward to fix that policy number and alignment. But when you look at 520 and what it means or the category of it, we just want to make sure we don't have anything competing with it. 520 itself is the overall general personnel policies. It doesn't hurt us to keep this one as 520. I don't have anything in competition with it, but really it's the heading for the category with that number. So either way, no harm, no foul on going either way on that numbering.
Right, I appreciate that, because my point was, if we're saying that we just want to be sure that folks land in the right spot that we intend them to, when we do the public participation piece, how we number it and where we organize it. I'm flexible with regard to that. And I do like the idea that if we have two competing sets of policies right now, that needs to be resolved.
So also speaking to Joel's comment, employees also have the grievance policy, which we'll get to as well, which there's certain things that are grievable. So that's also an avenue for them, but it's very specific around which pieces you would take by a grievance policy versus which one you would take just by a complaint. And I think by removing this existing 520, it really makes it clear, all right, it's either a grievance or just a concern or complaint. Because really, we currently have 3 venues, right? And we're going to narrow that to 2, but grievance is very clearly defined as the reason. So that's at least cleaned it up.
I like the new 521.1. I'd be in favor of adopting that and getting rid of 520 completely. I see it as somewhat redundant, and I see 521.1 as just literally more common sense as an employee and a board member, anybody who's employed here in the district.
And I then we'll add the 187, the cleanup on that reference to that. We'll bring it at the same time so that it's an automatic. We'll make sure the board understands that. But I think it also, I think WASB did a nice job in really thinking about, like you said, it's not just about complaining. It's around setting a philosophy of the board that you are encouraging us to seek and listen to the input of ideas of staff members. And those, it's setting a foundational piece of philosophy around how we want to operate as an organization. And I think that's important.
Yeah, at the very end of staff communications,
Mhm.
all district employees are expected to pursue personal grievances and personal complaints related to their employment through the established supervisory lines of authority, through an appropriate internal complaint grievance process, and we have that in place.
Yep, and we're gonna review it tonight.
So,
It's helping them, like you said, the point isn't to confound people, it's to point them in the right direction.
Yeah.
So,
Right.
right, we'll add that. 522 is new, it's on staff conduct. This is completely new, we did not have this in place prior. And it's just talking about the expectation that we're gonna comply with all these pieces, and sets that expectation. Now, a lot of times you're signing off as an employee annually on receiving a handbook, receiving those things, but it's another piece that reiterates that that's an expectation.
This is fine. It seems like Mr. Honored said, that this seems like good common sense.
pretty basic stuff, yeah.
I know, it's nice when you get some of the more technical series. Because as we said, there's a lot of statute, there's a lot of federal guidance, there's a lot of clear expectations. The next one.
I'm sorry, can I go back to
Go
that
ahead.
just very, very quickly? I don't object to the language, but in the second last line, the words immoral conduct are there, and they're in quotations, which would seem to indicate that that has kind of a magic definition. Do we mean it that way? Is there a definition? Are those quotation marks necessary?
So I can look and make sure with WASB, the intention of the language, whether the quotations need to be present or not. It could be leaning on a statutory definition
Right?
in there, so I'll do some double checking on that
Okay.
to get that answer.
Yeah, but assuming they're not necessary or they're,
Yep, I'll make that
Then we'll-
inquiry and have that as a follow-up piece, and we can go from there. If
Perfect.
you're comfortable bringing that forward, and I either remove or hold,
Mhm.
and then define, a little bit more clearly define immoral conduct then,
perfect.
or reference that that's a statutory definition.
Thank you.
Yeah, the only similar language I can think that is sometimes cited is like moral turpitude, areas of moral turpitude. I literally would just ask WASB, which they think is
Right.
more, better applicable in those situations.
The next one is a dual piece. Again, we have 516, which is right beneath the one you're looking at, 522.1. 516 was the original. It was a drug-free workplace. It was last revised in 2015. The one in front of you, 522.1, so you can look at them side by side. There is new WASB template language, a full replacement for 516. So it'll give you time to look at that.
So this is illegal drugs and alcohol, and then 522.2 is tobacco.
Well, and it's more than illegal drugs, so it would,
Inhalants and.
well, and or, the inappropriate use of
Illegal drugs.
prescription drugs and things
Under
like
the
that.
influence
Sure.
in a manner that's illegal or renders you ineffective.
The previous policy was just drug-free workplace, and there's more of an emphasis on just drugs, and alcohol is kind of tangentially mentioned, but the new policy really considers them kind of side by side, which is a little bit just cleaner for us because it's obviously the same problem regardless of which substance it is.
Medications, all of those, again, might have been initially prescribed in an illegal manner, but there could be abuse there.
Got it.
So Lenny, I'll ask you this question from the HR perspective. So when we look at the old policy, the very second paragraph, which is quite brief, talks about the use of drugs for medical purposes that may affect behavior performance. Employees are encouraged to advise the supervisor. So in other words, legal use for a legal reason. The new policy doesn't say that. I'm not sure it necessarily has to, because I know sometimes that can be a little bit awkward that you're essentially requiring someone to talk about a medical issue with their supervisor.
Right.
So I'm guessing that's why it's not in there, but I don't want to speculate, and maybe you'd be speculating, but
Well,
Go ahead and
you're-
speculate.
You are correctly speculating. So, because when you put it in policy, even though it doesn't say you must, it starts to make it sound like we are highly encouraging it, and are we now highly encouraging you to, violate your right to privacy around your personal medications? While that may be good advice in certain situations, to put it in policy as a maybe isn't particularly effective, right? Policy should generally say, you should do this and not do this. And as a maybe, I don't know that that's particularly effective, as well as the piece that you are alluding to, which is, does our policy tell people to disclose their medical, conditions? Because if it said you must, that's obviously not legal. So by taking it out, we kind of avoid any impropriety that way.
Yes, that was my guess as to why the WASB template might not have that exact language, and I'm okay with that.
Yeah, I think we can review the handbook as a supplementary piece where it is more providing some guidance. Hey, if there's something that may impact your work, way more general, connect with your supervisor, HR, how to get connected with the right people, but again, not forcing someone's hand on something. Certainly, if we were seeing an impairment in work, we would be having conversations with the employee. Okay. The next one, as you noted, was 522.2, which was really getting into the use of tobacco and related products. We recently did a little bit of one that covered generally the staff, the students. It was about having things present on grounds. So we made sure to check that one for alignment with the language here. Again, this is focused solely on staff.
One piece that, in more recent years, vaping is cited in this policy, which, several years ago wouldn't have been, but we did not have something in policy specific around tobacco. That isn't to say we didn't have rules. We could rely on the law, obviously, on those things, but putting in policy, if we're gonna put drugs and alcohol, then we felt appropriate to have.
So is this all repeated in the employee handbooks as well?
These are sections that we repeat in the employee handbook.
So you can strike my remark, this is employee use, correct?
Correct.
So this is not student, this is
No.
employee, okay.
We have a student piece, and then again, we have aligned language and replication for consequences for students, for staff, et cetera, if you were bringing anything on grounds as well. So we had that marked out in a couple spots. So you'll see some student discipline ones, you'll see the staff piece, and then you'll see it for being on property. Again, checking for alignment with all three.
That's good.
That next one you might want to do is side by side. So remember, this one was 522.2. That's the correct number. So work with me on this. The next one is 522.2. We're recommending removal of this and replacing it with its correct number and updated language, which is 523.1. So I would recommend for action, you're actually removing the current 522.2.
Okay.
And then right behind it is what I'm recommending, which would be a new number and completely updated language. And that's around staff physical examinations. So it just got convoluted there where the numbers were off. So I just wanted to make sure everyone followed that. So we're going to remove our current 522.2. We're gonna put a new one in place that's really about tobacco. Then we're gonna put 523.1 in place, which takes care of the content that was in this old one. Again, the intention is around staff physical examinations.
And there's statute around physical examinations, so this is really echoing, our commitment to enforcing that. And these are physical examinations primarily you're talking about when someone is newly hired.
Tuberculosis is mentioned in here. Is there a drug test as a condition of employment?
So for transportation, that is a condition of employment. It is not a condition of employment for other positions.
Is there anything, I know this is a WASB template, I'm a little surprised there's not like a statute or something. Is there a state statute that talks about?
Yep, we're gonna get to 523, which is around drug testing. And we can talk about current practice and intended practice, future practice, but we'll get to drug testing specifically, a couple policies from now.
But specifically for the health examination performed by a qualified medical practitioner as a condition of employment for new employees. Is that a statute?
So I think I'll find that and we'll reference
Reference
it.
it.
There is statute around that. I'm surprised.
So recall, sometimes the statute reference is not sitting in the narrative of the policy itself. What's missing on all these when we update these, there's a whole bottom portion that gives you every single legal reference and statute, and we actually make them clickable links.
Oh, great.
So then they can go right on that. So you will see all of those Wisconsin state statutes, any policy cross-reference, and then we put in a link to it. So as soon as we update that, then it's just a little bit easier for them to get background, cross-references, or statutes.
That's what I was wondering, like,
Yeah.
is it legal
Yes,
to
yes.
test somebody for tuberculosis?
Yes.
Okay.
Yeah, the tuberculosis one is in statute. that
Okay.
you must jump
Well, and tuberculosis has changed over our tenure in education. It used to be a certain kind of test, then there was, options for chest x-rays, then it's certain cadres of people, then there's different questionnaires now. So that's evolved
Okay.
over time as well. Okay, so that takes care of the physical examinations and kind of that slate of fixing the numbers, updating different languages. The next one was a workplace violence, threats, and harassment. It's new, it's WASB template language. We just kind of looked at different pieces, really went back, not just in Mr. Hansen's tenure as director, but certainly our experiences across systems, my tenure as overseeing HR and being in other systems, what helps you to execute, on policy and do what you need to do. So this was one. I don't know if you want to add anything.
Well, we referenced pieces like this in the handbook, but really it should be rooted in policy and then it just moves over to the handbook. So it's not that we didn't address this, but I think it's much stronger when done this way.
There's nothing here that I objected to. And I think a lot of it is common sense. So just examining this, since this is in the personnel section, it probably goes without saying, but we're talking about violence, threats, harassment between district employees or district employees and students. I mean, it applies to the whole thing, or
So
what's the
any
intended
of those
scope?
kinds of acts by an employee, regardless of who it's towards, whether it's to an employee, a student, community member, anything, it's
Right.
anyone,
Good.
any employee who is engaging in that behavior.
Good. Thank you.
The next was 522.7. There's no recommendation for changes, nor was there any WASB template language. You can see again, the pieces of technology had been attended to. The last review was July of 2020, and it's staff use of information technology and communication resources. There's no recommendation for change here.
Good.
The next was a 523 called job descriptions. It's a two-liner about having a job description. We recommend removal, it's not necessary.
I would agree, because the second sentence says that human resources will obey the law, which is good. Don't know we have to double say that. And then the first one is do what's in the job description, which is the purpose of the job description. So I would
And again,
support removal.
those pieces are present in evaluative tools. It doesn't mean if this goes away that someone, no, can't get caught not doing my job, nope, that's not.
Makes you wonder why we needed this policy back in
Because it's
2009.
not a WASB policy.
It's
a
something that's
homegrown numbered and written.
So again, we feel, like you said, you wonder, well, why did we need that? Well, our checks and balances, as you said, there's legal requirements around having job expectations. And then what's occurred since when it was started in 2009 was a massive overhaul of the state evaluation system. And those expectations and consistency and all of that. So it could have been in that limbo of evaluative systems, but those are all really solid. So again, if someone's not performing that, they'd be evaluated on.
Well, and maybe it's just just to be sure we're on the same page, because I think someone looking at this might say, well, I don't know, that policy didn't really hurt anything, why don't you keep it? But at least in the private sector, the idea would be, well, it doesn't hurt, but it doesn't really add a lot of substance, and if we keep it, it has to be maintained. We have to be very, very sure that by accident, some other policy might not be in conflict, and so if it really doesn't add value, I think that's the main reason to remove it.
The next piece to Joel's point was employee alcohol and drug testing. This is new WASB template language, and it goes in, as Joel said, for reasonable suspicion. It talks about the nuances of people who hold a CDL and drive. Remember, we're a mixed platform, meaning not only do we hire out transportation through a vendor, but we also have contracted drivers within. So there's nuances around those who hold a CDL. But to Joel's point in talking about onboarding specifically, this is getting into the when you would do that, but Lenny can speak to current practice around onboarding. That's not in there at this point. So if that's something that you want to explore that practice, then we'd have to add that.
This also sets our standard as to when we would engage in this at reasonable suspicion. So it clearly states what the standard of concern is to allow us to engage in using the policy.
So again, just to be clear, I apologize, is this is brand new language, or is it new language replacing some old language?
This one was
52311, brand new, it's new. Okay.
brand new, so
Great.
stated, yeah. So this is an ad around that specific, because to Joel's point, but.
So, the first paragraph, talking about reasonable suspicion of an employee who may be on duty or, let's say, drinking before coming to perform their job. And the district needs to have a trained supervisor observe these behaviors. Who's a trained supervisor?
So actually, that's a piece that we would go through, and there's some kind of checklists and some worksheets of leading you through your observations around behavior, physical presence, those kinds of things. So most often what happens is not only do you have some preliminary training as a site supervisor, but then if you have that suspicion, you're reaching out to one of us, we're engaging and walking alongside that person in a consistent process around screening, and application of that. And advising. So someone would call, I have this suspicion, okay, we're gonna come and support that.
And I would imagine in most cases, the police department would be involved, correct?
So they can be, there's oftentimes in a situation like this, when they occur in other districts, a legal intersection there, and often the legal police matter side of it is addressed first before the employment side. Right, so police are contracted, they take care of things from their angle, and then after their investigation is complete, then the employer steps in to conduct the investigation on the employment level.
What would a test look like in a situation where, we think someone may have shown up to work drunk, and a trained supervisor thinks that there is, reasonable suspicion there, the employee will be required to undergo a drug and alcohol test. Do we have the capability of doing this?
Sometimes you take them right to the employee clinic.
We have there's kind of two levels of that. So if police are involved, they will likely engage in a field test. But we have actually a contract with a local major hospital vendor where for any kind of testing, where we can come by and do testing at that moment, we would take that person to that testing site right away.
Okay.
The next one is, it was 532, it should be renumbered 523.2. The language would remain staff communicable diseases, bloodborne pathogens. I can see there's a spacing issue in that title. I'll correct that. It's diseases, if there's that.
Slash and
Yeah,
S,
yeah,
just
yeah.
inverted, that's okay.
Exactly. So I'll fix that. But no recommendation. It was last revised 2019. This is in coordination with, so right in our online portal for our employees, your bloodborne pathogens, your training, all of your support, your resources, this is a policy, and then there's certainly supporting pieces that go with it.
And this is rooted in statute as well.
Good.
The next one was interesting. It's 523.6, and it's going around the staff health and safety and employee right to know about toxic substances. We would recommend removal due to compliance and coverage in multiple other state and federal mandates. So we are actually posting and we're in compliance with those things. So it's not, it's just to your point with this policy, it's not saying that you don't have a right to know, it's that it's covered in multiple other places, and we need to be fluid enough to adapt with statute or federal guidelines. There's posting places, as part of our checks and balances, we brought Dave in, we looked at where these posted, where these accessible, it's still there. We would maintain that practice because we need to legally, but the policy, like you said, to maintain it could be a barrier.
Right. Thank you for that explanation, because I looked at this and thought, boy, I'm not an OSHA expert, but this sure looks like a lot of this is covered by OSHA. And so you run the risk in a policy like this. So if you're gonna go through this, then we gotta keep it current with OSHA. And I'm not sure.
Correct.
So there's timelines in this policy that many OSHA timelines would be even more rapid than, right? So why do we have a policy that has a lower standard than what the law is anyways?
I can't.
Right, we can't. And so then it becomes confusing, and it goes back to the earlier point. That's why these redundant policies are, while you look at it and say, well, I don't know, this policy
Yeah,
looks good.
Sounds good.
It
We've had
does.
it for almost 40 years.
Right.
This policy.
Right, we don't want to accidentally codify a practice that actually is illegal.
Well, and these, laws around this change much more rapidly now than they did 40 years ago when this got adopted.
Agreed, yeah.
So again, our employees do have the right to know, those are posted, they're available online, those things are there, we fully support that. Just the policy would be a barrier right now. The next is 526. Right behind it is 524 personnel records. So previously we had it listed as 524, it actually should be 526 personnel records. Again, in looking at it, it was some old language. We would recommend that we remove the existing 524, update both the language and the number to the 526 that you see before you.
So the existing policy, let's see, it's the beginning of the third paragraph of the pre-existing policy. Has a timeline for making the request, 7 days, et cetera. Doesn't have that in the new policy, but I'm wondering if that original policy was based in a time when personnel records were paper-based, and so it took a while to assemble it. I'm not sure if having a time frame is advisable or not. I'd be curious to hear your thoughts.
So we still use paper personnel records, okay? So that has not changed. Certainly there's elements around payroll and things like that that are electronic, but those aren't some of the core elements when you think of some of these bulleted points around policy. That timeline that's in there was, that's an artificial, there's no statute around that. Really, it's just, our requirement is to provide it within a timely basis. When someone does want to view their personnel record, what typically happens is someone will come in, a human resources team member is there with the individual as they view their personnel file, and then they can request a copy as well. And usually if anybody wants to come in and look at something, they don't request a copy, actually. They usually just request to come in and view it and see if, want to check a note or something that's in there. That's what typically happens. But since there is no statute, anytime there's no statutory timeline, when you set your own, you end up in situations then where, what if that request is made over winter break and, because the holidays fall a certain way, now we don't make the timeline. So, it's not for lack of trying, but the idea that now you put yourself in violation of policy over kind of a technicality unnecessarily would be a reason to remove that.
Makes sense.
Does Wisconsin have statutes on releasing personnel files to third parties? Is there relevant law out there?
So I don't know if I call it law as much as case law. So based on historical precedent around what has happened when individuals have requested those, that's more where that is rooted in. Certainly open record law has some bearing on that, but open record law is a little bit vague on it. And then I would say it's more relied on case law on how that has played out in various situations. The balancing tests of the public's need to know versus the employee's right to privacy, those balancing tests can't really be put in statute, they're kind of evaluated on the merits of each individual case that way.
I think that may have been maybe incorrectly referenced in the old policy of basically access of personnel files by third parties will be denied unless in compliance with open records law. And in the new policy, it says they shall be released to third parties, but only in accordance with relevant law. And I hope this doesn't happen, but when my son's class schedule comes out for next fall, and I want to request the personnel file of every single new teacher he has for next year, I would sure as heck hope that would be denied by someone requesting that. Is there law or case law that would prove me right
On
there?
that
or-
specific example, I don't know, but I would say the balancing test would not favor the requester in that situation. The public's need to know in that situation for maintenance of the public trust and so forth is not significant enough to justify the release of the record, is my interpretation. But I think it's pretty accurate interpretation.
We would deny it, based on our belief that if that were a challenge, then someone could challenge it and we would engage legal counsel in the challenge of that to prevail.
Okay, and I guess that was maybe my follow-up, you maybe just answered it. Should we have more policy in here on something like that? Because the way it reads now, the personnel records shall be released to third parties only in accordance with relevant law. And so if you deny me, I'm gonna say, well, where's the relevant law?
Then
And you would have that.
We
correct?
do, because people make requests and then we talk about, well, in the balancing this, I've written many correspondences where I deny something, this doesn't meet that, but how can I help you? What is it that you're interested in knowing? What about this? How can I help you with that?
And there's a lot of additions that have taken place to the law around that. So some additions in recent years are, if you are going to have to consider releasing personnel records, timelines to notify that employee, because that employee then has the ability
Right
to
to look
challenge
at it.
that. Well,
To
the employee
challenge it.
challenge the release. So
Sure.
those things are kind of constantly changing. There's timelines there. So whereas we can certainly reword that sentence, I wouldn't want to get too specific because that law changes not every year, but it's definitely updated from time to time. And the case law on that changes, I would say annually. There's cases in the state that take place that change the interpretation slightly.
When I was looking at it from a different angle, because when I looked at the old language, which talked about access to personnel files be denied unless in compliance with open records law, maybe it's just a hazard of the business that I'm in. If the court serves a subpoena on the district, likely that has to be complied with,
Right.
regardless of open records law. So I didn't like that, but the new one, personnel records will be released in accordance with relevant law, that would cover that scenario. I don't know, and that doesn't happen often, I know, but I acknowledge that this is a changing, fluid area.
I think, Joel, to your point, you're just talking about the won't versus will. You can say it with the denial, and you can say will be denied unless it's in accordance with relevant law. If it's, like you said, but it sounds like it's sounding a little bit more stronger to you around, this is gonna be denied unless it's in accordance. So instead of saying it positively, we will, in accordance with law, we can say these will be denied unless the release is within relevant law. I mean, would you prefer to,
What do you think?
I actually do like it worded that way to start with. The default is the request will be denied unless.
And then the other thing to think about in that is, even in situations where you are releasing, there's often several redactions. So it's never an all or nothing. There's often a lot of redacting that may take place that person has right to.
And the law guides that.
I appreciate that. We have, nearly 1,000 employees, and we have 40,000, people in our communities that we serve. And there are certainly employees out there that people in the community don't like and maybe out to get somebody, and, rumors spread, and I want to see their personnel file. Well,
That's what you got.
So I'm kind of looking at this as
Yeah.
I hate to say it, because, there are laws there are reasons why some of this needs to be transparent to the community, but employees also have a right to privacy and protection of their employment and personnel,
Well, and beyond just the employees' rights, so one of the pieces that has played heavily in a lot of balancing testimonies that come up is for the general good of public employers to be able to hire employees. If those employees think that their personnel file is always going to be an open book to the community, that would impede a public employer's ability to possibly recruit and retain staff. So that is factored into some of those balancing tests when they're taking place at the court level.
I think that rewrite of that line meets the needs.
Okay, thank you.
The next was 527, grievance procedure. We've got some suggestions for revision. They don't take place until the next page. They're highlighted with some green new language and a strike through, largely around what constitutes timely manner, 10 days. Same thing that Lenny spoke to a little bit before around what if this fell under this, talking about, there's references to 30 days to make sure those are calendar days. People don't misinterpret that as business days. That's way too lengthy. And then in addition, the very last one, there was a random 0.1 and no 0.2, so we just consider making that its own full sentence there for that last one. So take a look at those changes in context and let us know what you think.
That's good.
Thanks.
Good.
The next one is, was labeled as 531. We recommend renumbering it to 532.41, family and medical leave. The language would remain the same.
This is one where obviously we're obligated by law. There's no legal obligation to have this policy, but again, removal of it is not necessary either. We don't want to make it look like we're trying to remove any rights that people have, so we're fine continuing with it as it's worded. This is law that actually the law doesn't change that often, but it's very complicated. And then there's both Wisconsin and federal FMLA. So by keeping it brief, it allows us to just reference the statute and move from there.
Right. My first read of this was, gosh, I don't know that we need this at all for all the reasons we talked about before. But I know at least at our company, family medical leave is something that is commonly asked in certain situations. And so I think it's fine to have it. And again, because this doesn't talk about all the requirements of FMLA, it just says we'll abide by it. And you're right, there's the concurrency between FMLA and the Wisconsin equivalent of FMLA.
The only thing, well, I said the language remains the same. In looking at this now, we don't reference it. It's referenced in the title that FMLA, what it stands for. It's implied in the title, but that first reference it should be spelled out first, FMLA in parentheses following, and then there. I would recommend that change. Sometimes our brains know exactly what it means to say.
Better be precise.
Yeah, so I think that needs to be spelled out. I'd recommend that.
Well, the other part I think that's important about this is to clarify that leave between those two acts runs concurrently. So I think that's good to clarify as opposed to consecutively.
The next one is nepotism. was labeled as 511.1. I believe this was language written by previous boards. It should technically be numbered 533.2. So this is just our existing language. There is no template for this. We highlighted a couple key areas that we really wanted to make sure we discuss. Lenny, do you want to kind of call those out and speak to why we were questioning?
Quick question,
Yeah.
how do you know it should be 533.2 if it's not a WASB?
So just because they don't have a template or stock language, they're telling you where it falls, in which categories and which lineups. So we're matching it into there. And it makes sure that the number we've picked isn't in conflict with something that it, a 511 is equal opportunity employment. So while it might have some things in there, but in your 533, it's around your recruiting, your hiring, and there's actually a specific nepotism line. They don't have specific language. That's something a district pursues.
Does WASB recommend this policy?
No.
And obviously not, they don't require it.
No, sometimes you see this concept a little bit more in a handbook, and it's creating positional lines of authority, because if there's any, and again, West Bend is, you know, a wonderfully sized community. There's a lot of relationships, a lot of families, a lot of family names, if you can see them on the streets and the employees. You're just making sure there's chains of authority between, you know, that someone's not directly supervising their own family, that kind of piece. But there were some pieces in here, I think, very specific that we wanted to highlight.
So the first section under A, which is under 3, talks about, this again is homegrown language by the previous school board. Talks about in a rare instance where someone does need to basically violate the policy for any, I don't know how to say it any better than that. So the whole first four,
We're like, why would you
paragraphs-
have this? Why would you position someone to be in that position at all? It shouldn't be there.
So the first 4 paragraphs say this cannot happen.
And then
the
you
fifth
make a
paragraph
caveat
says,
to
but
have
the
it with-
time when it does happen occasionally,
It's okay. So we would recommend to get rid of that.
we just won't.
It negated the preambles.
Yeah, if we're gonna have a nepotism policy, we don't allow it. So that's that first highlighted section. The second one is point 4 about grandfathering. So there's a few problems with that. I mean, we don't allow nepotism, so we don't have situations that require grandfathering right now. And it was really grandfathering at the time of the policy. Well, the policy was adopted 5 years ago, so grandfathering shouldn't matter anymore, so we can remove that. And then the other side that just is problematic with that is it talks about that grandfathering ends at the end of that contract. Well, not every staff member here is contracted. There's many at-will employees, right? So, it kind of only considers maybe teachers or certified staff or administrators, but there are hundreds of employees who are not contracted. So in general, I would remove, if we're gonna keep the policy, which I have no problem having a policy, I really don't. I mean, it's gonna appear in the handbook no matter what. So I kind of like if the board is clear about what their opinion on nepotism is and how you define it, right? Because some people might define nepotism as just can't hire your own child, whereas others may say you can't hire your second cousin twice removed on your brother's son, you know what I mean? So it's kind of nice for us, for the board to clearly state what counts as nepotism or not, so I don't mind that, but I would recommend removal of point 4 and the highlighted section in point 3A.
Not only that, you should think philosophically about your own position as board members and when you have to hire and when you're voting on contracts. It's in the first paragraph, and I think that maybe could be one of those lines where it's fully expected that any board member in such a situation recuse himself or herself on certain pieces of hiring, promotion, valuation, compensation. And when does that render a board member in conflict of interest? And what would you have to recuse yourself from? And does it interfere with the position? Because I think that might have been largely where some of that language came in, was really thinking about the board and their role in having to potentially have decision-making authority.
Jen, no, just a technicality. In the second paragraph, there's 2 commas.
I caught it.
Okay.
I'm like, I got that one circled,
Yeah,
not highlighted, but circled.
That is in the original adoption,
Yeah.
so it was adopted with that error.
Right. We'll fix that. I'm like, what family member did they cut out at one point? Because it's aunt, uncle, then.
There are aspects about this policy that I like. You know, I like the idea that, gee, you should avoid things that are just blatant conflicts. I'm looking at it just to be sure I understand the words, because I think there are some things that could accidentally creep in, that could unintentionally, that could cause unknown conflicts, and what happens in a case like that. I like the idea of the rare instance elimination and the grandfather instance, since this is passed. I think this is one that requires further thought, to be honest, but.
What we can do, because there is no template, because it's usually nepotism is found in a handbook, and it talks about, you know, against different positional authority. I can talk with WASB around reviewing our specific language and helping us to navigate that.
And that'd be a good idea. I'm not against having the policy. I just want to be sure that the words here aren't, that the words are precise enough that we have a great chance of actually complying with it.
Great.
I like the fact, or the idea of sending this maybe to WASB to have them take a peek. You know, defining family members, brother-in-law, sister-in-law, mother-in-law.
That's rough. Like,
Former spouse.
right.
So, you know, let's say that my wife is a teacher in the district, and my niece on my side of the Ondert family wants to run for the school board.
Right.
Is that not okay? You know, I married, you know what I'm saying, on my side of the family, it's my brother's daughter is related, you know.
So, yeah, the more extended you get there, the more abstaining from various votes that takes place for that board member, right?
And does it dissuade someone from service? Because all of a sudden, that person may or may not have any authority based on the way this language is written.
Right. And, you know, I've been to WASB trainings a handful of times. The board has one employee, and that is the superintendent. Now, granted, the board does make decisions on some pay increases, but it's not typically done by individuals. It's done by, you know, let's say certified teaching staff, or it's done by the custodial or the lifeguards. We just did you know.
And you get into arguments around, you know, any contract, because you have to approve contracts, you have to approve, as you said, you're setting salary ranges, you're setting a district budget. People could argue that, well, any dollar that goes to, you know, elementary schools, and
Right.
your wife's an elementary teacher, like, what about this, that kind of thing. So I think the approach of having them specifically engage in reviewing our language and making a recommendation, even though they don't have templates for this, and then grabbing some handbook samples as well, because they certainly legally advise on handbook in those pieces. So I'll ask them to look a little bit more broadly on that for us.
And I think as an elected official, there is a responsibility of the individual to know where nepotism or conflicts of interest may exist. If I work for Dunder Mifflin Paper Company and the district buys paper from Dunder Mifflin all the time, I would probably need to abstain from a vote on buying that paper, you know what I'm saying?
Right.
And I would need to, as the elected official, that's, in my opinion, that's my responsibility to know when it's time to.
And you have, again, to your point, there's pieces that guide your own work in conflict of interest, but also incompatibility of office are some pieces as well. So I think just looking at this with a closer lens and asking for legal consult makes sense.
There's no way a school district like a Campbell Sport could have a policy like this, otherwise.
In a very small community, again, we're almost at the point, like I can look at generational families, that's something to
Yeah.
celebrate, but you know, how do you make sure that we're inclusive, but we're not, again, we've never positioned someone to be overseeing their own family, that kind of thing. So I think
There's a big difference between if you have the authority to act on something specific to that individual, like their contract, versus something that's specific only to the entire staff, like
Correct.
pay raises, handbook rules, things like that. I think there's a tangible difference there, because let's say, Joel, your relative is going to be off the contract. you can easily abstain from that, and we can still function as a body by having the other 6 members still vote. But if it prevents you from engaging in anything that for all employees at once, yeah, in a small community, maybe West Bend's small with lots of connections, but in a real small one, you could hamstring the board from being able to ever give a pay raise or, things like that, or change benefits.
Or to even invite people to run for school board.
Well, yeah, and I feel passionate about this because as soon as this policy was adopted, we had a school board member resign because of the policy. And I don't want to put words into her mouth, but she was a great board member who, after this was passed, felt like she could no longer serve because of this policy being in place as it related to a family member working in a district. I don't like to see that happening. I think, anyway, you can.
We will take that forward.
Yeah, I think it was.
We've got our policy meetings scheduled in succession, so to dig into that one deeper, I think makes sense.
Yeah, and I think in fairness, if we could just ask WASB to talk about pros and cons.
Yeah.
Right, because I can see benefits here.
And
I
like
just
I
want to
said,
be sure we're not,
I'll have them
tripped up.
expand it to beyond policy, even handbook language, that we would lean on, that kind of thing, as supplementary. The next was 534, that's a incorrect number. We would recommend removal. These concepts are covered in both handbook and law. This was about workers' compensation and light duty.
We put incorrect number, but I actually don't think there is a number.
Yeah.
I don't think WASB has a policy.
No, 534 is about substitute teachers, so it's for sure incorrect.
no, although as a worker, not the workers' compensation insurer of the district, working for a workers' compensation insurer, it's great to see that there's a light duty program.
And again, that information is available to employees in their handbook. The next one is 536.5. It's, we have revisions recommended. We do not recommend that those take place until September 1. This is a reduction in force policy, both for contracted staff, the one right behind is support staff. We're looking for some shifts in timelines. In this, Lenny can speak to that, but we don't recommend that it take effect till September 1 because we're right in that window right now of staffing and projecting staff. And we would not want to make any change while in process of timelines. We would recommend this would start new with the school year, that we're not changing anything while we're in play. So again, those are highlighted. You can see it's just really in this first one, identifying the length of service in a contracted position. And
There is
striking
a
through.
tracked change that did not get counted as tracked, so I wanna
Can you highlight that for us?
So on the back side,
Can you speak to that
Sure.
length of service and some
it's
of that?
under reemployment, in case I forget by the time I get there.
Yep.
So,
I gotcha.
so the only, there's only 2 track changes that we would recommend. So the length of service, it previously just said, the length of service is, defined as when you were first hired here. Being a school district, that this has not come up, but I can foresee a problem we can run into. So there are people that might work here for 20 years as a coach or as a ticket taker at basketball games and then become a paraprofessional. Well, the way it's written, they would get years of service for the 20 years they were an occasional ticket taker, and that would jump them ahead of a number of people. And obviously, that's not the
It's like
the
false
spirit of
seniority.
yeah, it's not the spirit of the rule. So instead, since this is around contracted staff, we said when you moved into a contracted position is when the timeline starts for counting your service. And we haven't been in that spot, but as I thought about this, that could really put us in a position that isn't really what the board intended when I adopted this.
Lenny, just thinking about that, I know what we mean, you know what you mean. Do we need to say certified position?
Well,
Or
this
is
actually,
contracted
this
okay?
applies to administrators and certified staff. This policy covers both of them.
I'm just thinking of in your illustration, a coach would receive they would perceive that as a
That's a good
contract.
point. We could,
So I think we might need to look at that.
a certified staff or administrator contract, let's
Yeah,
detail that. a
we'll
little bit
play around with that to just make sure it says what we mean it to. I wouldn't want people to falsely believe that they're entering into a contract when they're a support staff.
position. So just something as we think about it. And then you said reemployment, Lenny.
I do want to highlight, just because I want it to be, transparent, if you have thoughts on this. So this kind of groups in the way that we're talking about wording on contracted administrators and certified staff together. So we've had several cases in the last 20 years where maybe someone was a teacher here, they went to an administrator position. They did that for 5, 10 years and said, you know what, I want to return to teaching. Their timeline would not reset when they switch back from a teacher to administrator, administrator to a teacher under the way it's written here. So, which I'm okay with. We've had that happen where someone served in whatever administrative position, and that was the time of their life for that. They might have done that for a decade for us, but then they wanted to move back to a certified staff position to finish their career. My thought is I would not want that choice to kind of switch back and forth to work against that person if time would come up to make a decision on not bringing them back. So the way that we're talking about writing this, their timeline would not reset when switching between administrator and certified because they're still contracted. But I want to at least be transparent about that, so that if you had other thoughts that we could consider those.
I think that's fair. I think the other way would be
Right.
quite unfair.
Right.
Well, it creates an incentive to stay in something that maybe isn't, you did it for a decade, but now that's not where you want to be. Keeping people locked in a spot that maybe isn't where they're most engaged. So I think the way we're talking about it is better for the employees.
Great.
I agree. Okay. The second piece there is under reemployment process, the reemployment period is we changed the date there. Now, this is part of the reason we would want to delay the implementation of this policy until September, because we'd like the current staffing season to pass. That previously said August 10th, okay? And what this refers to is, let's say we have to unfortunately lay off an employee because of declining enrollment, those sorts of things. The reemployment period is, okay, I had to lay you off on April 30th, but another teacher in your area resigns or resigns May 15th. Instead of reposting that job, I pick up the phone and say, hey, we've got a spot for you now to come back. You have the option to return. That's the reemployment period. It was previously August 10th. We have not had to use this, but as I think about how this can play out, August 10th is pretty late in the season and timelines are extremely tight for hiring at that point. It may be better for us to move that timeline up. By August 10th, that individual's probably found another position anyway. But we could be sitting there, waiting for a response for several days, missing out on candidates when we are mere 2 or 3 weeks from the start of the school year. So that's a concern. The other thing is that all teachers, by statute, have to return their new contract for the new year by June 15th. So June 30th gives plenty of time for the mail and that sort of thing, that by June 30th, we know who's returned. They've returned a contract. So I feel that it's not necessary to go beyond that date, and it avoids hamstringing our recruitment processes, which those August times when we have to recruit at the last minute are extremely competitive, and I don't want to hamstring the district in that way. So that's the reason that June 30th is suggested.
That makes sense.
Like I said, Lenny highlighted our statutory deadlines to return those things and make that declaration, or even earlier. So it's not like we've shifted something for an employee tremendously. Again, we have to turn it in earlier.
Sounds good.
As noted, very similar, that's, the next one is the reduction in force for support staff. We've got revisions recommended. I'll have Lenny walk you through, again, September effective date, so we're not changing something inside of a school year here.
So this policy, the same type of change as the first one we talked about. There is no reemployment period in this one, so we don't need to discuss that because these are at-will employees. They're not operating on a contract, so the timelines don't operate the same way. However, wanted to avoid the same situation we talked about earlier where someone maybe is working very part-time for us for several years. That really should not count as accrued service. So instead, what we indicated is that the length of service with the district would be dependent on when they were in their current employee group. So within support staff, we do get transfers, in a decent amount at a time. So you may have someone that works in the school nutrition department for 5 years, and then they move over to a paraprofessional position. Under the way we worded this, when they move to paraprofessional, their length of service would reset at that point. They, paraprofessional, very different position, and to leapfrog all of those experienced people in that area, I think from the staff's perspective, would not fit, as they believe, kind of that decisions should operate. It's just such a much very different position. So we, in this case, advocate when you change employee types or employee groups, and we have those categorized, that you would reset your years of service.
Good,
That's the only change.
that's good.
Yes, agreed.
The next is 526. It should be numbered as 538. The language remains, it's around staff evaluations. It's just setting that expectation of evaluation that employees should receive them.
The only thing I would like to add here is who gives the employee this, appropriate suggestion for improvement? Because it doesn't really say in here, and, if I'm a parent in the district and I see staff evaluation policy and I read this, I could think to myself, oh, okay, I think I'm gonna go ahead and write an evaluation for, my third grade teacher, and I would expect that gets put in their file,
Not quite how that works.
But, because it talks about it, every employee shall receive periodic written evaluations of his or her performance, maybe by their supervisor or something like that.
Sure. Yeah, because for obvious reasons, we wouldn't want to get real specific about, in fact, some previous language we had seen in some older policies in the district said the principal. Well, the principal isn't always the evaluator. In the facilities department, it's a shift supervisor, something like that. So we would go with either supervisor or superintendent or superintendent's designee, and the designee is whoever the superintendent identifies. That would probably be the two ways I would go with it.
Agreed.
And maybe I'm just being a little nitpicky on that, but,
That's good
In
clarification.
the absence of clarity,
board members don't have the authority to write staff
That's correct.
evaluations,
no, we do not.
so.
No, but you can also, if that's a piece, you can add a line in there, not only who evaluates that person, but then it's my responsibility and my designee to oversee that there's a comprehensive evaluation program in the district. You could put in a line around that, again, so there's no perceived value. There's a line, the district, we use the word superintendent specifically, but the superintendent and/or designee is responsible for the overall evaluation program. We have one that notes further that I'm your one employee. You are actually responsible to evaluate me, all board members. So that's there. But I think, like you said, maybe a couple sentences that give kind of the who, and maybe a sentence about like, hey, we're holding ourselves responsible as an organization for this. Meets that name? Okay. Okay.
There's that very last paragraph, last sentence really, is the periodic performance evaluations. Basically, when there's the existence of a performance or disciplinary problem. I mean, isn't that kind of what a evaluation is?
I think what it's making clear is it's not just your end of year evaluation, that we can provide evaluation feedback at any time, and that is the case. And teachers are evaluated, their evaluations are driven largely by statute that was put in place, I don't know if that was 2009 or so forth, but around how many times a year and things like that.
So it's giving us the authority that at any moment, we can flip right back into an evaluative piece. Any time that you're working, right, you can technically be evaluated.
Yeah, that's
So
what's
they can't
in
say,
mind.
they can't say like, oh, sorry, yep, not on schedule, not my evaluation year, not kind of that. It's like you said, it's like, it's just saying,
All the time.
yeah, kind of on promise.
And make sure there's a period at the end of that. Okay, thanks for just a couple.
We'll get a couple sentences in there, highlight those, and then make sure that speaks to what you were thinking. The next one is professional development opportunities. That would be 541, it's a homegrown, we recommend removal. This concept around professional development opportunities is in the handbook. You see those, it's part of sometimes we speak openly about our professional learning, all of that, and then participating in those is part of the formal evaluation process. We talked about that getting a significant overhaul at the state level. That's right in the evaluation.
Now, part of some of our compensation
Exactly.
opportunities and things.
So those come before you, and as a point of kind of in our communications, we've been highlighting on professional learning days, always, not just a reminder, hey, keep your kids at home, but hey, guess what? Everyone's engaged in and highlighting those as well, to make sure that we're communicating and with our community too. So there's no need for this policy. We don't feel.
Agreed.
This is the next one is 542. This is new. This is giving the authority to approve support staff positions to a superintendent or designee. What happens in these positions, these are often the turnover of support staff positions of school nutrition employee, a custodian, a paraprofessional, the churn on those. They're not the cycle of like, hey, every year we're engaged in a teacher, they're lesser positions. They're governed by the board in the framework that we put before you. This is the range of employee, this is the category, this is what you can do. This doesn't give us any special authority. It means I'm not held up waiting for the next board meeting to get someone formally approved, that we can move on those support staff positions with all those parameters. It is nothing that you need to do. I also know that this board is very responsive and will pull together if I need something immediately and do that. But there's certainly been times in this hiring market, when Lenny and I talked about it, it's something I had in my former district, and talked about kind of what he's faced this year in the hiring of those support staff positions and the cycles of onboarding. So it was just something we talked about, at least bringing forward for your consideration. I don't know if you've.
So statute requires that only the board can enter into contracts. So that's why, no matter what, certified staff, teachers, administrators, those contracts can
Have to.
only go into effect if you approve them. But on at-will employees, there is no statute. So this really gives us the authority to act and not, and as she said, the timelines on those positions can be much more difficult to work for. So this gives us that authority to hire support staff well within the statutory realm, but without having to bring it to board.
Also, only within those parameters in which we're authorized. You set the category, we have a recommendation based on them meeting the tenets of that, for that job, and you've set the range. We're not authorized to then bring someone in and set some kind of odd salary. It has to be within the range that you've established at the board. So it might be something that you just want to think more deeply about. It's just been an interesting market to recruit and retain. And we've done a lot of work around, changing compensation and making sure we're market compatible. Like I said, I also know that I have a very responsive board. And if we said, holy cow, this is creating a problem, I need to get you in right now because this is holding us up. So something for you to explore and think about.
I would say this authority is pretty common in school districts.
I'm in favor of it. I don't see, typically these positions, as you said, they're within a classification, there's salary or pay ranges, and not typically, but always, there's been a budget approved,
Correct.
an annual
Exactly.
budget. I mean, you're not
Exactly.
you're not just gonna go out and hire 20 people because you want 20 new whatever.
It's the
gotta-
illusion of
it's gotta
authority,
fit
if you
within-
will. It's the illusion of authority. To your point, it has to be, there's a staffing plan. We have the positions allocated. It's generally a replacement for, or we usually, in that staffing plan, we call out, there's a contingency position if numbers get that way. And again, no contracts, no certified staff. So again, almost the illusion of authority in that it's budgeted, you have a preliminary staffing plan, and all those ranges are set.
Sounds good.
Right. Well, then we want to look at the kind of our spreadsheet. We have touched every single one in the 500. We made some recommendations for some removals, and really worked through that intersection. Was there anything? Takes all of us to, like I said, you can lose sight of numbers, but is there anything that I might have overlooked?
I think we covered all the ones that we need to. We touched every policy, added some new ones as well.
So as far as proceeding then, we had one to really dig into. Yes, certainly we can put these for a reading in front of. I would wait until the May meeting. There's no rush. We have a board meeting on Monday. I don't see any rush. I could do the interim work on getting consult with WASB. I can speak to it. And Joel can put it in his policy committee update. I don't see the need unless you do then, if we do it through the update process with the board, around getting that one to look into, we'll make those others and then start putting these for review for the board in May. That'd be okay?
That timeline's fine with me, I think.
And again,
All
going through
this-
the first, second review and all of that, but
Right,
unless you wanted it to come back to committee specifically on that, I think we could use the committee update structure, that this was, that what you asked us to look into, and here's that, and here's the.
And you said
those
to
couple
advance it
sentences, yep. And
when it's right.
Yep, I'll have you look at that, and let you know what
Yes.
legal consult says, so.
Great.
I'm okay with that in May, so then there would be no second committee meeting around the 500s specifically. We'd start moving on into that next series, which would be the 300s around instruction. And we've got our meetings on the docket, quite a few of them in May.
I was just taking a look at that. We have a regular board meeting on April 18th, and Aaron Dove and Paul Fisher, that will be their last board meeting.
Correct.
And then on May 2nd, we have a policy committee meeting at 4 o'clock, and on May 3rd, a curriculum committee meeting at 8 o'clock. Will, I know you've done some onboarding with Melanie Ergat and John Donaldson. Have they expressed interest in serving on either of these committees? Can they serve on these committees, or is there a formal process of putting them on the committees?
Yes, there is. So yes, we're welcoming 2 new board members, and John Donaldson has expressed interest. What we do at our May meeting, when we welcome new members, we go through all the committees, the assignments, those pieces. We give them time to contemplate, and at that second May meeting, we'll make it official. So while we might be running as a team of 2 as we explore that, I talked about as an onboarding piece, if they're going to be declaring interest in joining, I would work alongside, so that new person might not be sitting at the table, but we'd be getting that input and not moving forward until they're onboarded and being able to participate.
So I know this isn't my committee, but like curriculum on May 3rd, without, that committee only has 2 members at the moment, so will that committee be able to even hold a meeting?
No, they, I believe, were canceling and regrouping, that they, because again, they're down to 1 remaining. I believe that they were canceling out their meetings and convening after that you had time to express interest in joining. Because the other piece too, and I've already foreshadowed to our new members, that while our policy committee, I talked about our commitment to kind of resetting our cycle. We knew that we were digging in deep and having a lot more meetings this year to do that. And then we talked about the timing that actually works. But committees, when they reform, they re-examine when they meet to make sure that it's an accessible time. So in future board members who have expressed interest in policy, the time worked. And we just talked about getting engaged with this and making sure they have a background. Because we'll start exploring the 300s, but we won't be bringing anything forward. They'll actually be seated at the table and with us for the 500 series that we bring forward. So it's
To the board, to the full
correct,
board.
so that's
Correct.
part of the full board.
Yeah.
So they'll be part of that piece too.
Great.
And I can't remember when I want to be on policy, Chris wants to be, is there a formal action of the board that we are making these people the official policy
Correct.
committee?
You
Okay.
are at that second
Okay.
meeting in May. That's when we,
Because I was gonna say, if John Donaldson wants to be here on the 2nd and 5th, we have 2 meetings scheduled, May 2nd, May 5th, and actually participate. That's fine with me, but if he has to officially be.
cannot participate,
Okay,
can be present, can talk about it, I can engage, he can view, but then we would work separately, like, oh, what
Yeah.
views do you have? We wouldn't move it forward out of committee So right now, we're gonna move these forward because our committee met and all that, but we're not gonna move anything forward until we have our committee together.
And he will obviously be on the board in the official, school board meetings.
Right.
He will have a first reading, a
Yep,
second reading, a
correct.
third, which is
So it's
obviously
well timed.
the most important part is the voting on it.
Right.
We don't take any action in policy, and I'm sure you've talked to him about that. I haven't spoken to him yet, so,
So there was preliminary interest, and which is exciting,
Good.
Yeah.
to have that. I think we've operated well as a committee of three, so, again, we've done some orientation and I would do that still, so that people are ready to assume those positions in different committees.
I am, we're coming into the summer months here, and I know we've set meetings. I'm also very flexible, and I do want to be aggressive, I don't want to cancel meetings, but if for some reason dates and times that, don't work for him or for you anymore, or you guys, let us know, we'll reschedule, we can always do that.
Right.
I also don't want to keep you guys here past, it's probably easier to have meetings at 3:30, 4 o'clock than at 6,
It is, but we adjust for that. We understand and recognize that our board members have whole other jobs and obligations, that this is a piece of service you're committing to. We're flexible and we would flex our schedules to accommodate that.
Sounds good.
But yeah, there's been interest, like I said, every time we kind of reform, we reset, talk about what's on the calendar, does this work, does this not work? But again, there was preliminary interest and that the times actually worked. So, yeah, it was really exciting.
Sounds good.
Great.
Anything else?
Nope.
All right, I move to adjourn.
Second, all in favor?
Aye,
Aye. Thank you very much.
Thank you.
thank you.
Thank you, Steve.
Thank you.